Good afternoon, everyone, and thanks for joining us for today's webinar. Our panelists will be discussing actions taken just a few hours ago by the Judicial Council to help protect civil justice during the COVID-19 crisis. These actions were the result of several weeks of persistent advocacy by CAOC lobbyists and leaders. Today, you'll be hearing from CAOC President Micah Star-Liberty and our CEO and Chief Lobbyist, Nancy Drabble. If you have a question, please open the chat feature at the bottom of your screen and type out your query. Nancy and Michael will be answering as many as time allows. Now, let's welcome our panelists.
Hi, good afternoon. As Eric said, my name is Micah Star-Liberty. I'm the CAOC president. We wanted to get to you all, our members and stakeholders, information related to what we have been working on at CAOC over the past few weeks. First and foremost, we have taken several steps to ensure that we were speaking to the right people and communicating the right message to help keep your practices open. I'm just going to say that Chris or Eric, the PowerPoint's not visible, so hopefully the folks out there can actually see the PowerPoint. If y'all could share your screen, that would be fantastic. Okay, there we go, CAOC action. Bear with us, this is our first live CAOC webinar. So as much as we're pushing for everything to be able to be done remotely, we're still experiencing our own technical issues here at CAOC. Okay, so what action has CAOC taken to help protect you all and your clients? First, we sought emergency protections, not only with the governor, but also with the Judicial Council, and we'll be getting into the details of those actions in a few moments. Additionally, once we saw the first Superior Court shut down, which was Contra Costa County on March 15th, we saw the wave that was coming, and we started immediately to gather our resources, identify what issues were important to you all so that we could hit the ground running as the rest of the court systems shut down. But we wanted to make sure that just on a day-to-day basis, you all could keep your doors open, even remotely, and help protect your clients. So we were providing some member resources to you.
Thank you, Micah. So I don't know whether you would like to discuss the resources further that are appearing on the screen now.
Sure, I'll just briefly go over it. There's two things that we've tried to do. One is keep you up to date as to which courts are open and closed and what to expect with respect to the emergency orders each Superior Court has not only the power to issue, but that they are issuing on almost a daily basis. So we created a web page, a landing page that you can get to through our website, which has up-to-date emergency orders for all 58 counties. And we are updating them in real time. So if you have a question about whether or not you can file something or when additional services will be provided or are anticipated, check out that website for the counties that you practice in so you know what to do with respect to your cases. Second, we've had will have had three webinars. So this has only been going on for about 3 weeks. And every single week, we've tried to bring you something to help you with your practice. First, past President Elise Sanguinetti and I did a webinar on how to run your office remotely. We included recommendations for software and hardware so that you could keep practicing law and keep advocating on behalf of your clients. Then past President Brian Kabatak did a webinar with folks from his firm to discuss insurance interruption claims that you and your clients could potentially make. And then this Thursday, the 9th, Laura Sedritz and Ramtin Gantin are doing a webinar on how to help your clients by seeking financial assistance. Thank you. Nancy, do you want to talk about what's happening in the legislature or not?
Yeah.
Case maybe?
Yes, thank you, Micah. So I'm sure many of you know that the legislature had to suspend its operations because of the crisis. And at first it was going to be suspended until April 13th. But with the necessity for the additional quarantine period, now it's going to be in recess at least until May 4th. And so as a result, it was very clear that there was no way that we could have the legislature act in this crisis because it was going to take too long. And so we had to turn to the other two branches of government to get immediate relief for all of you who are trying to still work on your cases during this crisis. So our next step was to go to the Judicial Council and see whether they had the authority to act. But unfortunately, under the California Constitution, the Chief Justice has very limited authority to act. Her emergency powers are really shockingly constrained. And so as a result, we did turn our attention to the governor's office, to the third branch of government. If you could move on to the next slide. And so when we went to the governor's office, first we asked all of you, what are your most urgent and immediate problems? Because we had to identify what you needed us to try to accomplish for you during this period. And the three issues that you came back to us with were that you were very concerned about the tolling of the statute of limitations, about whether your clients could lose their legal rights if you were unable to file your cases while the courts were closed. Second, whether you could conduct fully remote depositions. And third, whether you could have electronic service on opposing counsel. So those were our initial three priorities that we went to the governor's office with. And we also, during this period, got the California Defense Council to join us so that we could be united in our request to the governor's office.
Now let's move on to the executive order we were able to achieve. Last Friday, the Friday before last, I think the time-space continuum has taken on new meanings during this time, 2 Fridays ago, after about a week of outreach and drafting. Once we had an understanding of your priorities, drafting language to encourage the governor to issue an executive order so we could protect your ability to practice law and our clients' rights, we were finally able to achieve getting an executive order from the governor. And he did 2 things specifically that were unprecedented and yet very, very necessary in this difficult time. One, he granted our Chief Justice authority to handle the issues that we were trying to get him to issue orders on. So specifically, he suspended 2 statutes. One was to allow remote depositions and suggested suspending the statute provision, which requires deposition officers to be in the same room as the witness, and 2, to allow for electronic service without the need to have a stipulation. He also indicated that there should be a tolling of the statute of limitations, but really left a lot of power and authority to the Chief Justice as the more appropriate branch to flesh out those issues.
So once the governor issued his executive order, and by the way, I just want to interject here that it was no easy task to try to persuade the governor to address these issues in the legal system when he was dealing with the most serious health issues and triaging what he needed to do on a day-to-day basis. So I do think it's a tribute to many of our members and those of us who've worked with the governor's office that he did prioritize the legal system as he attempted to navigate a very, very difficult time. And he chose to give the Chief Justice the authority to deal with these issues. So now our venue switched back over to the Chief Justice, back over to the Judicial Council, because now she has adequate authority to deal with this emergency situation. So at that point, we went back to you, our members, and asked you for an expanded list of what you felt was most urgent. So we had our original 3 items: the tolling of the statute of limitations, electronic service, and remote depositions. But at that point, you also told us that it was critical to extend the 5-year statute so that you would not have your cases dismissed if you came to the end of the 5 years during the emergency period. You told us that it was critical to have minors' comp petitions be considered on an expeditious basis. You also told us you needed the courts to be working remotely as much as was feasible. And last, but definitely not least, you told us that it was critical that there be some statewide guidance on what would happen to motions that you are facing during this emergency period, and also what will happen on the uniform rescheduling of trials once the emergency period is over. So we put all 7 of those requests back at the Judicial Council just a little over a week ago.
And I'll just add, we've been working behind the scenes every weekend and late into the night to try and do our best to provide both of these branches of government with language as well as coalition building with their stakeholders, just so we're giving them everything they need to act to help your clients. And I'm so proud of the work that we were able to do and what we've been able to accomplish. So all of that hard work leads us to today. And the Judicial Council had an emergency meeting and took some action. Chris, thank you. So 3 things were dealt with today. 1, the Judicial Council and the Chief voted on and issued an emergency order to toll the statute of limitations starting April 6th until 90 days after the governor lifts the state of emergency. Many people who have seen the press releases have asked why April 6th. That's the authority she was specifically granted by the governor. So when the governor issued his emergency order on March 27th, he gave the chief the authority to pass whatever emergency rules she saw fit, starting the day of the passage. So I hope that provides a basis and some context for you all who are asking that very reasonable question. 2, they passed Rule 10, which increases the 5-year trial rule by 6 months. 3, they passed the totally remote deposition rule in Rule 11, allowing us to continue to take depositions where the deposition officer need not be in the same room as the deponent. But there's still more to come. Nancy?
Thank you, Micah. As far as the additional items, I will comment on those, but I wanted to add on the remote depositions to make it clear that that can be requested by either party. So you do not have to get a stipulation from your opposing counsel in order to conduct a remote deposition. If a lawyer still wants to be in the room with his or her client, that is available, but your opposing counsel cannot block you from having a remote deposition. So we do have an unfinished agenda of the remaining items. And if we'll turn to the next slide, 2 we're expecting fast action on. In the meeting just a couple of hours ago, there was a clear commitment by the Chief Justice and the other leaders of the Judicial Council that they are going to act quickly on some of our other issues. And our understanding is in particular on electronic service on counsel and making sure that minors' comp hearings can be conducted remotely. We are expecting very expeditious action from the Judicial Council. And so watch this space. We are hopeful that that will occur very soon, as soon as they can finish writing the language, and we will definitely be keeping the pressure on them for that to occur as fast as possible.
And yet more remains. The Judicial Council has yet to issue any emergency orders with respect to what happens to motions that are currently pending in terms of when the hearing dates will be rescheduled, and importantly, when new deadlines are for motions that were due statutorily during this time frame, as well as what to do about the civil trial schedule. We have asked for the court to prioritize statutory preference cases, cases that had to, that were mistried because they started trial and then the courts were shut down, and then cases set for trial during this time period where the entire court system has essentially come to a grinding halt. So we are going to continue all of our advocacy efforts. We're going to continue to work with our stakeholders and provide as much support to the Judicial Council in order to get clear and, as much as we can, get consolidated and coordinated rules to help you calendar once this shutdown has ended.
So those are the major action items that remain. And I'm sure many of you have been looking to see what the orders are in your 58 different courts. And while each of those courts is doing their best to handle these issues, the input we've gotten from all of you is you do want uniform guidance at the statewide level, and we are here to make sure that that happens. So I think that concludes our PowerPoint. Before we conclude, though, I do want to give a shout out to Savina Takar, whose name you see on the screen there. Savina has been working very closely with Mike and I. I would also like to acknowledge Leanne Tratton, who has been working just in an extremely strategic and effective way in making these things happen, which to do in the middle of a crisis. And one last thank you I want to give is to Gretchen Nelson, who is on the Judicial Council, who is a plaintiff's lawyer in Los Angeles, who I'm sure many of you know, and she presented the civil rule changes very effectively at the Judicial Council today. So I want to thank Gretchen Nelson.
Absolutely, and I echo all of those thanks, and I thank all of you for the continued work that you do, your support of CAOC, and for your membership. Great,
thank you, Micah and Nancy. Now let's move on to the Q&A portion. If you have a question, just hit the chat box down at the bottom of the screen, and you can type in your question. A few folks have already done so, so let's get going. Right off the top, there's one I can answer. It is, are the webinars available for those who missed them? And the answer to that is yes. Now for you two ladies, will we be able to file new civil complaints? And if so, what is the procedure for doing so?
Micah, would you like to take that one?
Sure. As soon as Dropbox service opens or electronic service providers are able to accept filings, you can go ahead and file. You want to watch and look at our 58 county webpage to figure out the county that you want to file in, whether or not they're open and accepting filings. For example, my understanding is today Contra Costa County has opened up a Dropbox. We still don't have any clarity on when, whether or not the documents, the pleadings are going to be marked received or they're going to be marked filed, but you just want to get in whatever you need to get in as soon as possible to the appropriate county.
Great. Laurel Halbany asks, will we be able to file new civil complaints? And if so, well, we just asked that one. Let's move on to Vincent De Simone. He has a minor's compromise where the minor and parents have compromised health conditions, placing them at risk. The parents are also plaintiffs and they need the money pretty desperately. Can minors' comp cases be decided without a court appearance? He also asked, can you do ex partes telephonically? He's in San Bernardino, and he's wondering if they can get this to our trial judge, who has been good on the case, or if we can.
Well, that's exactly the reason we need the Judicial Council to issue the statewide order to ensure that you can do exactly that. that the people do not have to appear in court, and also that they can be done remotely. That is what we were asking for minors compromise, and that is what we were anticipating the state order will say.
And that'll be in what's called a circulating order. And just so everyone knows, everyone on the Judicial Council understands that issue and understands that there's a lot at stake when a child's case or a special needs adult's case has resolved. So we anticipate a circulating order to be circulated as soon as possible.
Yes.
Jeff Rudman asks, if the remote depot rule goes into effect immediately, or does there need to be a local court order first?
No, it goes into effect immediately. They've adopted it, it's done.
Great. Eduardo Robles asked on the SOL issue, what about those cases where the SOL runs out between the court's closure of March 16th and today's orders of April 6th, 2020?
Yeah, that's definitely a problem. It's something that we talked about in all of our communications with the governor's office, as well as the Judicial Council. Because the governor specifically only authorized the chief to have orders be effective the date they were issued, there wasn't any room to make them retroactive. However, if necessary, we can talk to our folks in the legislature and try and issue get some cleanup legislation to take care of cases that fall within that. We think it's about a 2-week period. But if you have that issue, please contact us, because as folks know, we need to be able to provide the legislature with examples as to how big of an issue this is. Keep in mind that if the courts are closed, most of them are counting those court closure days as court holidays. So your case may not be impacted in actuality.
Just to follow up on that, we already have talked to legislative leaders about this potential gap period, but as Micah mentioned, we would need to show that people's legal rights had been harmed during that 2-week gap period, and there wasn't some other remedy, or that there was an actual problem. So they totally understand that if courts were closed and somebody could not file their case, that's not right. So we will see whether we do need to have emergency legislation to remedy it retroactively.
Scott Sumner has a question about the 6-month claims deadline. Are there any issues with public entity claims against various cities and municipalities for which the 6-month claims deadline occurs during this lockdown?
I'm not totally sure I understand the question, but that's never stopped me from trying to answer one before. So what I would say, Scott, is that I read the language regarding the SOLs very broadly. I suggest that we all interpret that language very broadly.
Right.
Rose asked, for clarification, the e-service option sought, is that just for existing cases or also for service of summons and complaints?
It's for service on any represented party. So if you know that a defendant is represented, I think you can take advantage of this emergency rule, but it is limited to parties and their representative, their legal representative.
Okay. Straight from San Diego, Brett Schreiber asks, well, first he has a statement, thank you all for your work. And he asks, how do we enforce the requirement that depots proceed remotely when there is no court to force the hand of a recalcitrant defendant?
That's a really good question, Brett. And so one thing that we have asked for is whether we could have motions to compel or have judges consider this type of problem remotely. it's clear that at the moment they are prioritizing the remote hearings that relate to criminal cases, juvenile dependency. We have asked that minors compromise issues be prioritized, but certainly the problem of making sure that you can conduct discovery, we have asked that that also be considered remotely.
Great. Larry Lalonde asks, can we get the governor and Chief Justice to issue an order that is in line with the frequently asked questions that came out of LASC, thanks to Gretchen and Brazil?
Well, Lori, I suppose it would depend on which part of it you are referring to, because I know that there have been a number of topics covered. Our goal has been to look at the issues we described, the ones that require uniform guidance on a statewide level. So to the extent that some of those issues are in the frequently asked questions, we can look at whether they should be added to our uniform statewide request.
The only other thing I would add is it's important for folks to remember that under the Constitution, each of these 58 county superior courts have authority to proceed in ways unique to them. So we are asking the Judicial Council to step into a breach in this extraordinary time and issue statewide orders. So that's our focus.
Mm-hmm.
Dylan Ruga asks, is there a time frame for when the courts plan to reopen or when they will begin hearing civil motions?
I don't think anybody knows the answer to that question. It just is the same as reopening anything in the state of California. I think that will be largely determined by the governor as we see how the health issues turn out.
Lori, on a similar line, Lori Andrus asks, any idea when the various counties will restart holding telephonic video hearings and case management conferences?
We wish we had that information. You know, one of the issues that keeps being brought to our attention is the different levels of technological acuity that the different superior courts have. So there are some counties who probably have the ability to have remote access and could start doing some things telephonically. And it has definitely been the chief's suggestion every time she's made a public statement for the different courts to do as much as they can in this period of time remotely. There are some counties, however, that just don't have that kind of technology. And then to be quite frank, the other piece of it is the labor issue with the rank and file union members not wanting to, rightfully so, go back into the office, so to speak. And if they don't have access remotely, that, you know, having a case management conference without the technology would require folks to be in the courtroom, which right now is not something that can happen.
But definitely we have raised the issue of judges being able to do whatever they can remotely, including conducting settlement conferences or other things which may not require as much participation by employees, where they can do something themselves remotely. And the chief really has directed the courts to do everything feasible to conduct all of their business remotely. So they are under instructions to try to accomplish that.
And in our conversations, kind of both behind the scenes and directly with the Judicial Council, there is acknowledgement and also a desire for things like mandatory settlement conferences to be to continue remotely. They understand and would like us to be able to continue to prosecute our cases, and they want to do what they can to help. It's really just a matter of, in this avalanche of emergency issues for the Judicial Council to deal with. That's not one that they've gotten to, but please be rest assured that we are going to continue to bring these up and to continue to push them in the direction of being able to get done what we need to get done during this time frame.
Kevin Callahan down in LA notes that many are trying to figure out what is happening with rescheduling trials that were vacated during the closure.
Yes, and on that particular issue, we have made a recommendation that, first of all, I believe you heard Micah discuss earlier that when they are ready to hold trials again, that they should prioritize, of course, preference cases, also trials that had a mistrial, so they were not able to be completed, and third, trials that would have been conducted during the emergency period. We have also recommended that there be a 75-day delay from the original trial date for any trial that falls within that category, and that be a statewide rule. And then if localities needed to make some additional adjustments, they could make that, but that would be the baseline. So that's our recommendation. However, there has not been action on that yet, and that is one of our biggest priorities, is to get a uniform order on that point.
Several people have questions about the statute of limitations and the 90 days. Several are wondering if a statute of limitation falls within the crisis period, will it be extended to the same date, i.e. 90 days after the crisis is over, or does the clock start after the crisis period?
No, as of today, so if their statute runs tomorrow on the 7th or a week from now when the courts are still closed, they'll have the 90 days whenever the governor lifts this state of emergency order. So the 90-day period starts ticking when the order is lifted for any statutes that run from today going forward in time while the courts are closed.
So for example, just to make follow up on Micah's comments, if the statute ran tomorrow, but the governor does not lift the emergency order until August, there would still be 90 days after that time in August for somebody to file that case. And our thinking on that was we couldn't have a situation where people were all trying to file their cases the day after the governor issued the order, that there needed to be some leeway and a grace period so that people would still have time to file cases after the emergency order was lifted.
Okay. Bill Nauman asked, do you expect the Judicial Council to set procedures for remote hearings on motions?
It's something that we would like to work with them on, but we are really taking these issues on a day-to-day basis and triaging, just like the Judicial Council is doing. And I have to just say, because we're used to things moving so quickly. The Judicial Council, however, and the entire court system is a deliberative body, and they take their time. So we have really gotten them to work at warp speed, quite frankly, on the issues that are important to us. As Nancy's mentioned, the next kind of focus really is going to be getting new deadlines for motions, as well as a statewide trial setting order. And that's our next priority. If we're at a point where we're lucky enough to have motion dates and hearing dates set, and there's still a health reason as to why folks can't appear in person, we will certainly work with the Judicial Council as much as we can to get them to try and do whatever they can remotely. But remember, the chief has already said every time she's spoken publicly about these issues that she expects all judicial officers to do as much as they can during this time remotely.
Whit Birch asks, does e-service apply to deposition subpoenas? For instance, attempting to take depositions of treating doctors and non-party witnesses, such as an investigating police officer.
If the recipient is a represented party.
Right. Yes.
Let's see. Is it correct now that there is no remedy available ex parte or otherwise if a defendant's counsel refuses to participate in a remote deposition? In my experience, defendants are refusing to participate.
Well, they were refusing to participate maybe until today when the Judicial Council issued an emergency order. I mean, right, if your local courthouse is not hearing ex partes or they're completely shut down and you can't get before the court, your remedy will potentially have to wait. But I can't imagine the response that a judge would have when things do get up and running again if a party blatantly refused when the Judicial Council issued an emergency order. So I would attach the emergency orders and links to the website. As a matter of fact, the Judicial Council meeting that occurred today will be recorded, and you can forward that link to folks. There's always going to be bad actors, and I wish there was something we could do about that. I would just suggest staying on them and letting them know what the ramifications will be if and when the court goes back into business.
Another question. If a civil matter requires probate approval of a settlement, is there a plan to have those hearings available similar to those hearings to approve minors' comps?
Well, as we've mentioned, we have taken our priority list from the literally hundreds of emails and text messages and voicemails that Nancy and I have gotten over the past 3 weeks. So our priorities are what we've stated. That's not to say that at some future point, we can't bring other issues to the Judicial Council's attention.
And if minors' comp petitions go before the probate department, then they would certainly fall within the circulating order that we would expect to have come out soon.
Yeah, I mean, minors' comps are handled differently by every county. So yeah, that's really going to be a site-specific question.
Kelly Hanker asks, are the statute of limitations still extended for counties where they are accepting electronic filings?
Yes. It's not dependent on what the counties are doing. It's a uniform state order.
Right, statewide.
Another question, defendants are also refusing to take remote depots. As I understand it, the emergency order doesn't require remote depots.
We just talked about that. The emergency order issued today says that you have the ability to take a completely remote deposition, having the witness, the deponent, and the deposition officer in separate locations so folks can socially distance appropriately.
So they cannot refuse on the basis that they do not want to do a remote deposition. Maybe they have some other reason, but it cannot be because they don't want to do a remote deposition.
Great. Well, panelists, thank you very much. I think we've pretty much reached the end of our time, and thank you for your wise insights.
Thank you very much. And everybody hang in there.